our distinguished panel of speakers, respectable members of the college, guests, media, you are all welcome this afternoon to the second edition of the College of Arbitrators Nigeria Seminar Series. We are most grateful for your presence here this afternoon. We know you could have been anywhere else, but you elected to be here with us. We do not take it for granted. My name is Chioma Onyenucheya Uko, and I'll be directing proceedings this afternoon. Effectively kick off, please permit me to invite you all to rise as we take the second stanza of the national anthem as our prayer this afternoon. O God of creation, direct our noble course, guide our leaders right, help our youths the truth to know, in love and honesty to grow, and live in just and true, great lofty heights attain, to build a nation where peace and justice shall reign. Amen. You may please be seated. May I introduce our panel for the day? And please, as I announce your name, I ask that you quickly rise to the table where we have a seat specially set out for you. And of course, the host will be leading that ascension to the table. So please welcome with me the president of the college, Mr. Patrick Ikwetu, Senior Advocate of Nigeria. Joining him quickly will be Mr. Suleiman Kuku Dawodu. We also have the esteemed presence of Mr. Oh, my apologies. I would have just goofed now, but I pray that you forgive that goof. I'm going to see how I remedy it because I don't quite have the details of the correction on me. That realization just struck me now. Forgive me. We have the Director Legal, the Economic and Financial Crimes Commission, a Senior Advocate of Nigeria, who is ably representing this afternoon. I said he is ably representing, yes, the chairman of the commission, Mr. Ola Olukoyode. You're welcome, sir. Then, of course, we have the cerebral ambassador, Shegun Ogunyanwo, also with us this afternoon. I hope I didn't mutilate that surname, sir. Okay. Fantastic. Okay, so we will go straight into it. No much ado. And as you all know, we are discussing the theme, restorative justice, the role of ADR in criminal justice administration in Nigeria. And I bet that at the end of this session, you would all agree with me that we couldn't have made a better choice of our faculty for this afternoon. But before the faculty commences, please welcome warmly the president of the college for his opening comments.
Our faculty, I welcome you very specially to today's event. Let me start on a note of apologize. As we all know, we have challenges in our country. We live in very difficult times. We thought about canceling this program late last night when we realized that the strike by the labor union was indeed a serious affair. Unfortunately, we couldn't just cancel it because we were afraid that if we did, it will still be the same thing that if we had had it to go on today. As you will know, most offices are closed. Most civil servants, even private workers, are not going to work. So I think that the reason why we have almost an empty hall is that the strike, most people would have thought that even this event wasn't going to take place. I apologize for what we are having this afternoon. But I'm happy that we will have our event recorded, and we will share this recording with relevant stakeholders, relevant agencies. And I want to say to you that all shortcomings are all ours. I apologize on our behalf for those shortcomings. Now, the theme of this today's discussion, restorative justice, the role of ADR in criminal justice administration in Nigeria. We all know that our country has come to a point where we know that the major reason why our nation is not progressing, why it's not moving forward, why we are where we are today, has to do with how we are managing our resources. And we at the College of Arbitrators thought that we will bring our expertise by calling those who know more than us, those who are also experts in the field, to discuss how ADR can assist in revamping the economy by way of assisting in retributive justice. And all we intend to achieve is to see the role ADR can play in dealing with, I don't want to use the word corruption, but corruption matters, and matters that are holding the economy down. So that's what we thought that we can discuss. And the panel that is assembled, from what I know, is the best you can get. So I welcome all of us today, and I thank the panel members who are here. I wasn't thinking I was going to sit on the dais with them, because my role only was just to welcome them, which I have done. So thank you very much for coming. I'm sure we'll get more as time goes on. Thank you.
Thank you very much, Mr. President. Okay, so we dive straight into the meat of our gathering this afternoon. And leading the pack will be the immediate past Executive Secretary of the Administration of Criminal Justice Monitoring Committee, and an erudite scholar, and of course, authority on the subject of restorative justice. Please welcome with me Mr. Suleiman Kuku Dawodu.
The distinguished president and my fellow panelists, ladies and gentlemen, good afternoon. It is a great honor to be here this afternoon and present this topical issue around our criminal justice. And I'm very much take it as a very privilege to be part of it. But I was hoping I could present my PowerPoint. Yes, please. Yeah, so that we can all be carried along together. Please bear with us whilst we do this logistics. Once again, good afternoon. My name, again, as I said, is Suleiman Kuku Dawodu. The concept of restorative justice as an ADR, which is alternative dispute resolution in criminal cases, that's what I've been asked to speak to. And in my introduction, I have referred to the current state of our criminal justice system, and I did point out how we all are aware and very much confirm how slow it is, how congested, and how it's also filled with loopholes and fluidity, which constantly the participant, which is whether the suspect or defendant, and sometimes also the prosecution, are always taking the advantage of that. and resulting in the, I said that some of these suspects eventually are evading, escaping prosecution, and the defendant also evading conviction, and those that are convicted also are released before their term due to the same challenge of the correctional centers congestion and inadequate facility in our penal institution. So this calls then to mind that we must then take some action, some steps to actually curb these challenges and menace and lapses within our criminal justice system. And I did also reiterate that it's all our responsibility as criminal justice stakeholders or as justice stakeholders to ensure that we cover these lapses in every possible ways, legitimate. And some have obviously been constantly, some stakeholders, school of thought, theorists, they've always been concerned about how to deal with it. And some have actually gone to the extent of suggesting that perhaps we could shift our jurisprudence from adversarial to accusatorial, just like you have in many other countries or jurisdictions across the world. And that's just show the concern and the seriousness of how we can deal with this reckless situation, and nothing more. And most of us will say that that is an extreme proposition, which I'm very much likely to agree. But it goes to show that something definitely needs to be done for all of us to get our system back in order. And so if we are not suggesting those extreme position or proposition, then we have something, an offer, in the offering itself, which is the alternative dispute resolution. So rather than letting all of these lapses to be continuing, why do we not apply the alternative dispute resolution in our criminal justice system? You will often see that very controversial. Some will say that is an exclusive civil matter. How could you be negotiating and mediating or arbitrating with the criminal, and so on and so forth? But having said that, that system has actually been recognized, not just in our civil procedure, but it has no doubt also become applicable and almost equally been given force of law with some in our criminal procedural laws at the federal level and at the many state levels as well. Many states have also adopted an alternative dispute resolution. So what are these sort of alternative disputes that are in place? And I've said that at the stages of ADR, spelling that out, mostly applicable at the investigation stage. And we see that a lot at the police stations and the law enforcement agencies. And I'm glad that my director legal is also here talking about law enforcement agencies. So it's not just about the police that are doing this. And also come up with the statistics to show that unofficial as it may be, but give or take, I'm sure whether it's more than that or lesser than that or just about lesser. But we are saying that over 50% of cases that comes before the police are actually settled in one way or the other. Admittedly, not in line with the procedure and the expected criteria that is expected of them to be documented and to be evidenced as is required. They're just going on a spree of settlement and all of that, and it's going on as we speak in many police stations. So it is not in doubt that it is actually with us, alternative dispute resolution. And we may be thankful to them for taking those proactive steps, because otherwise we wonder how many more cases will have congesting our docket and also the correctional service. So we said that even though it's taking place at the police station, some things need to be done, and we probably touch on that in how to do it properly and legally or lawfully, so that they are also very much transparent and accountable to the system. The second stage, I said, is the adjudication stage, which is happening all the time. And I've said large number of those cases that comes up for adjudication, especially at the lower court, are being settled day in, day out, especially within our magistrate court, the area court with criminal jurisdiction, and also in some states that have customary court that has a criminal jurisdiction. And you'll be surprised how many of those states of customary court do have criminal jurisdiction, especially in the north. So they are always settling matters, whether with the prosecution on the side or on some other arrangement or other being initiated by the bench themselves or itself, and these cases are settled. And the other instances that you will have is the practice of plea bargain, which no doubt it's another form of alternative dispute resolution. You're welcome, Milo. In criminal proceedings. So for this purpose, however, we are looking at restorative justice as one of those means of alternative dispute resolution. And that's the focus of this paper. So what is the restorative justice within the criminal proceedings? And it's been said that it's a theory of justice, emphasizing on the harm caused by criminal behavior. And please do take note of that. The harm itself is the focus, not the actual actus reus. But it's also a philosophy of crime and the punishment, focusing on repairing that particular harm caused by the crime to the victim and the offender and the community. It's a very much peculiar and new phenomenon. If you ask me, many of you are not aware of this concept, which is why it's also a very good forum for us to be always advocating and raising awareness of these principles or theory of law. The important thing to note is that it emphasizes on the importance of engaging the victim itself and consenting to that engagement with the offender, and the offender itself expressing the readiness and guilt to face the consequences of his action, and also at times it extends to the community level, that the community will also be involved, where the offending the victims are actually the larger community in the resolution of those crimes. So in essence, it is to protect the interests of the victims, the offenders to a large measure, and then obviously the society at large. That is the restorative justice. It sounds bizarre in a way, even as it sounds, alternative dispute sounds bizarre or strange to many. And we've now extended to the fact that not just the alternative dispute resolution, but you will have to be bringing the offender and the victims together, expressing guilt, expressing apology, direct apologies by the offender, and sometimes and that's premised on the basis that the victims is happy to take such apologies or some other compensation. Sometimes you get, but that is the whole essence. Again, that is something we will come up with in terms of how the practice, in terms of how it's actually practiced. But let's deal with a bit of more concept. At the extreme end, it's also confusing with what you call a transitional justice principle. Transitional justice is also another alternative dispute resolution within the criminal justice system. The difference with that is, as I said here, it aims to foster reconciliation between offenders, and rather than a particular person, transitional justice is dealing with more larger group or society or community rather than a particular individual person. Individual is the starting point of restorative justice, but it doesn't stop there. Sometimes it also extends to the society or larger group But it's different from transitional justice, where you will have panel of all these disputes that's been set up, commission of inquiry, and all that. Those are examples of transitional justice, where large, for instance, the Tutsi, Hutus, resolution, and all that, commission of the inquiry in relation to that. That is what the transitional justice, but this relates to purely that particular harm done to the society, and not when there is a war or other violence crisis that has occurred. That's usually followed by transitional justice. Having said that, the typical example that you will have depicting that sort of a larger group operation or restorative process is the de-radicalization program of terrorist and extreme violent cases that is currently going on, both in Gombe, Bauchi, where the government has, all those that are involved in the Boko Haram crisis are the defendant. Even when they are discharged, they are taken to the de-radicalization program, and it's going on as we speak. The Borno state government has also commenced another form of de-radicalization, and this time they are leveraging on what the failings of what the federal government is doing, and they are setting up their own separate reconciliatory and rehabilitative program on that school, transitional justice school, restorative justice. And we will get to hear more of that. Let's progress and go to the next one. And the focus, I think I've said that in many words, is from punitive measures to prevention of further harm is what the restorative justice is about. That is a very huge phenomenon to say, how on earth do you intend to curb, to prevent further harm where you are still facing the offender and the victims are still facing each other, and how much can you achieve, especially within our local context? How much could that assuage what has been done or the harm that has been done? That's something that we will look into as we progress. But the focus is what I've just said, actively involving the victim, offender, the community to address or repair those harm. And rather than relegating the victim, the focus is more on the victim. Let me move on and we'll speak more on that. So it says it's to promote healing and rehabilitation for all involved parties. And that's restorative justice. If that is the case, again, he's saying, apart from just not punitive and punishing, which it takes a while, it takes a long time for us to reach that point that you will then sentence that particular defendant. And that is the starting point of my discussion. Why wait for that long process before we get to the punitive of sentencing or such other sentence that may be given by the court? Whereas RJ is much focused on that direct result of what has happened, the harm that has been caused, and it seeks that philosophy to create a more compassionate and participatory system. Not only addresses the immediate consequence, but also promoting healing and rehabilitation, as I said. It sounds very, very philosophical, and that's why I've also referred to the, if you look at the financial crimes, and that's why I'll put the EFCC and the perpetrators, you then wonder what sort of harm and rehabilitation and healing could go on in financial crimes that are touching on the public funds and all of that. Would you expect then the EFCC to bring the offender and then who will be the victims? The state, who will be representing the state at that sort of sitting? Why would they be engaged? Is it not to deal more of a plea bargain? Or should we then say that the plea bargain is taking the position or taking also the shape of a restorative justice? If that is what, and I'm sure my director will address us on that format. I think most of his presentation will be centered around that. But that's just to show the focus and also highlight more of the concept of that restorative justice. So if you please talk about moral philosophy, and I'll go quickly around this because we still have a bit of cover, and I know I have limited time. So he said it's transformative approach. And so in essence, he believes RJ process offers the victim over the offender the benefit of being properly reformed and not through the punitive punishment, which I will also come back to. I'll refer to what is happening to the Boko Haram defendants presently who are still in Maiduguri and hoping to get a trial in Kainji. And we have been on that since last one was in 2017. Some of them have been charged as far back as 2019, but they've not been arraigned, even as bad as it were that they actually perpetrated that heinous crime of terrorism. But then they are still there, not arraigned, some of them not also being charged. Some of them as far back as 2014 that they've been arrested, some of them have not been charged. Well, anyway, that is just to show you the background of why we need to think outside the box around some other form of model that's actually deals with the seriousness or this transformation that we're really hoping to get or to achieve. And that is what the RJ is addressing. So transformative approach to crime and conflict. And that's a very good point. Conflict, you will have that more in transitional justice, and the crime, you'll have that in more restorative justice. That's another fine distinction. But then sometimes they actually goes together. You don't distinguish the conflict and the crime per se, especially the terrorism and extreme violence cases. So it says the relationship restoration is also an end. That's where you see, will that apply at the lower end to minor offenses? Is that what the case should be, that this restorative justice that Mr. Suleiman is talking about, we should be talking about minor offenses between neighbors, assault, and theft of this minor thing? Will that be what you say apology, you slap me once, twice, we fight, and then you say I need apology from that and it's resolved? But you say, but that's already going on anyway. The police are always doing that every day. And even at court, as I said, the magistrate will perhaps say, I'm withdrawing my charges, I'm happy to let go. But this is a larger concept within which we are talking about. And we will show that how it is done in terms of it actually need to be institutionalized. And it is only when it's institutionalized that it actually makes sense and not becomes a theory. Otherwise, this is theory. So let's go be theoretical and look at the philosophy behind the restorative justice. So he says, part of the restoration of relationship accountability healing process is that we are out to repair harm that is done. I think I've said that, much of that since the beginning. Highlighted that it addresses the root causes of that harm, is for that long-term resolution. And I've also queried that. Then should all cases then proceed to re-jail, or is there a distinction? Which is why I've said, should that be applicable to only minor offenses? Or how do you get this to other serious offenses, sexual offenses, child abuse, domestic violence? Will this also be applicable? Those are questions that we keep engaging ourselves, stakeholders, and we need to find a mechanism or come to terms in terms of defining, by way of having a standard operating procedure to guide the operation of restorative justice, which is what I was referring to as being institutionalizing restorative justice, so that we take our local content, we know what is applicable to us, how far we want to apply. Because what comes to mind is, you people have come with all these Onyibo idea and all that. That is always the first critics that we receive from this. But let's look at the essence, the bottom line of it. And it's predicated, as I said, next point is that RJ is predicated on voluntary participation. And there's no compulsion at all. It's only when the offender, the victim, signifies the intention to proceed by way of restorative justice. I'm happy to do that. It's a very hard decision. But that is the first condition. And it's also not binding on the offender to actually take up the process or procedure. They must also consent to that voluntary participation. And in essence, larger forum, larger sense that it involves inclusivity. As we said, everybody is taken on board. There's dialogue around that issue of how to reform that offender, if at all forgiveness will actually lead to reform or lead to the peace of the public peace, if we actually took those steps rather than another what you call it, proceeding, trial, court proceedings and all that. Why not we settle internally? And more essentially, the essence of accountability and responsibility is also key as a part of the philosophy of this concept, and also to the extent that is only when it actually leads to the offender being responsible, or there is a benefit accruing to the community by way of using that approach, and it's not an escape route to escape the traditional justice system or bypass all of that. So he says that's what the accountability and responsibility. It has to be shown that remorselessness that will actually lead to that reformation truly, and before you identify, or whether it's a judge or the police referring that for referring it to the Restorative Justice Center, which we will come up to as well in a few minutes. But having said that, the other part of the philosophy is the community involvement, and not just that is the offender. It can lead to a larger forum that is all being, the issues are being discussed and finding solution. It might take time. It's not one sitting that all this happens, as well as within the restorative justice. And that's part of the challenges also that we will contend with. We might actually come back to the same point that an adjournment, are we going on today? Sometimes you will find out that they will not be proceeding because the facilitators are not there. And we'll come to that. Who are the facilitators? Who takes on these challenges? Who conducts this RJ? Are they well trained? Who is training them? How trained are they? How ready are, how available are they? Because we'll come to that anyway. Let me leave that. So it is also focused on prevention, addressing the underlying causes of criminal behavior, promoting, it's saying it break the cycle of crime and contribute to a safer, harmonious society. It also, in a way that said, in terms of protection of human dignity, and I've referred to those Boko Haram defendants in Maiduguri and Wawa and Kuje detention facilities, and many other detainees who are detained without their cases being progressed. And I'm glad that Milord is here, that we work together on those sort of cases, highlighting one by one cases that have continuously been on the court record and docket for years without taking steps to get to that, and they are in custody. So you wonder some point, many a times, these have been the point that I've confronted the most of the practitioners, that most cases, these defendants spend even more time than the sentences that they will actually incur have they proceeded timely with their trial or proceedings. That is what the restorative justice seeks to also protect. Those human dignity, you don't keep people in custody longer than necessary, and why not if we could follow the other route? So it offers profound alternative to traditional justice approaches, but it's not an escape route, as I said. And whether, okay, that's the concept, the philosophy and all that. We're getting more practical now. And the question really that comes to mind on most practitioners is the fact that, again, should this really apply in criminal proceedings? That's the restorative justice now. We've gone beyond the arbitration and other alternative dispute resolution. Yes, but this has been given the force of law, so it's not more a debate. If you look at Section 1 of the ACJ, it speaks to the restorative justice principle in terms of the protection of the offenders, victim, and the community at large. And states have even gone further than that to make elaborate provision in their ACJL. Lagos State is the number one in terms of implementing restorative justice. And I recall how we, at the federal level, FCT, we actually went to visit Lagos to see how they conduct the RJ. We saw their center, and thankfully we have replicated that in FCT, and it's up and running. And I'm glad that we're having this sort of forum to see how this college also and other arbitration panels or bodies can actually support the center to actually be able to implement this alternative dispute resolution. So Delta is also a very good example of who is, they have provided that elaborately in their ACJL, but I do not think they have kickstarted the process of institutionalizing it, to the best of my knowledge, as of this early this year. So the other question is whether this should be applicable to also serious offenses. As I said earlier on, sexual offenses, abuse of children, trafficking, terrorism, kidnapping, banditry, and all that. We will have, of course, to address that at some point in the next clip as well. The other question that's also raised is, what then happens to that person that's gone through the RJ? Is that person discharged and acquitted? Or must there be a conviction before you can recourse to the restorative justice? Otherwise, as we said, it is not an escape route for traditional justice system. It complements traditional justice system. Then it beats us and every serious-minded person to say, this jury you are bringing, would that end those just lead to everybody being let out for whatever offenses you'll be discharged because you have gone through restorative justice? And these are issues that are being within practitioners and continue to engage them. But we will have, of course, to discuss that. But the simple answer to that is that it depends on how institutionalizing it, and because that's what we are promoting, to ensure that this concept is not just a theory, but it's institutionalized. And there are processes that has to be gone through, which we will have, of course, to, so that in some cases, yes, it might be a case that a first offender will probably let go by way of caution. In the usual way it happens. The ACJ also provides for that. So it depends on the offense, the circumstances and the offender, the background, the antecedent. Does he have criminal record? Is it the first time? Is it a minor offense? Will it lead to discharge? Will it help? Or must there be a conviction? Then it has to be referred to the magistrate to endorse the whatever agreement that has been done. We'll come to that. And again, it's also a question whether all this concept, beautiful as it appears, is it actually sustainable in our criminal justice system? We're still struggling with the traditional justice system. You're coming up with RJ Center to do that. Will it be sustainable? That's a very million-dollar question that we will all have to probe ourselves and be serious about it. But it depends on how well we'll understand the old concept itself, which is why we're taking time to express, to go through these concepts and the requisite of it before it could work. And frankly, we have said that the sustainability is also premised on a strong criminal justice system, which we are saying from the beginning that we are struggling with. So how then can we build this on nothing or on something that is wobbling? Well, that is what for us as stakeholders to contend with, and where there's a will, there's a way, especially when he's also talking about alternative justice, which we already have a body like this body of college and others who can support that process. And also, realistically, it's also very expensive, to be honest. Well, we'll come to that, because when it comes to the facilitators, just like you have the arbitrators and you have all these fellows, everybody wants to be fellows, and so that you become an arbitrator, you have that hit case, and you'll get your million in a few minutes, you arbitrator. Who will be the arbitrator here in the criminal proceedings, in this RJ? That's where the problem comes in. It has to be driven by experts. The same way you have arbitrator in civil cases, this concept is driven by also by facilitators who are also arbitrators in criminal proceedings dealing with this matter. They have to be trained. The question whether they will have, when they are trained, just like Lagos is confronted with, they trained a lot of facilitators, and now they are also asking, listen, we need to be paid. We can't do voluntary. And So, and who is going to be paying them? Ministry of Justice, court, and all that is something that we deal with when we're facing the challenges. But it's an issue that we have to confront from the beginning. It's expensive. And we have asked how many of us will be able to do those voluntary work. Lagos is struggling. At the moment, they are the first pace setter. But then, credit to those who are actually volunteering, and there are quite a number of them. So how many of us will be able to support, and that's something that will put one of the take-home for us, so that as we qualify also for an arbitrators in criminal alternative dispute, in criminal proceedings, how much sacrifice could you do, especially at this stage, that you are not going to be paid a lot. Anyway, we'll come to that, and I'm glad that the director for the RJS Center is here. So quickly, I'll also run through the proponent, which might not be unnecessary because I think I've dealt with that. There's been encounter, there will be inclusiveness, there will be accountability, and reparation, restoration, empowerment, healing, flexibility is what we are saying is also a major asset of this concept. It's not that courtroom proceedings, the fear of hearsay evidence and all that admissibility are not there, and so it gives that room for expression on the part of the both offenders, both the victims, and all the other members that are participating. It's not that threatening as you'll have in courtroom, and it's not beset with all those precedents and also criteria and all the rest of it, evidential issues. So educational issue, let me look forward. Again, is a collaboration within the legal system, and it's not meant to complement it and not replacing them. Accountability issue, and in the end, we are hoping that it will contribute to a holistic and human-centered approach. That's also a key word I did not highlight. A holistic and human-centered approach to addressing harm and fostering a sense of justice. Another beautiful word or phrase, fostering a sense of justice, that no matter what happens, everyone will go out of there and they'll be happy that I've been able to express myself. I've been able to express how this harm has caused my family, affected everyone, and the defendant also is appreciating how the significant harm that has been done to those person or family or the community, and is ready to make a reform and also compensate and all the others, and obviously community well-being in the end. At the end of the day, okay, so the school of thought in the serious, how much of this should apply to serious offenses. Some of us on this side, we have seen that perhaps RJ is even more applicable with the serious offenses than even the minor offenses, because those one will continue to go at the police station. You will not be able to, at the lower court, except the RJ Center really get on hold and get to be in charge of that processes. And that's the only way we can be rest assured that those minor offenses might actually be caught up within the restorative justice, only because of our sentiment and because of our, sometimes we say that a bit of lack of seriousness on our part, with due respect. So we're saying this will be more even relevant where you will have more serious cases, and I've said that the Boko Haram cases. So the question then is, I know that many will be very concerned to say, oh, so you are creating a forum for the terrorists to actually escape justice. But then I've referred you to people who are likely to have been sentenced to 10 years and they have already spent 12 years. Those who will be sentenced 10 years and probably need to spend 7 years, but they're already spending 9 years because of just abandonment of those their cases. And so that is what led the Borno government to say that we will not adopt the federal government de-radicalization process. We will do and so as we speak, Borno state government is doing their own RJ qualified de-radicalization, and they are not referring the cases to the authorities. So they are just granting amnesty and following up a healing process or rehabilitation process. They call it rehabilitation process. So all those low-level people that are involved, whether they reckon that they were forced to participate or they are the low-level participant, and even some mid-level as well. And that's because they have seen that this is not working. The traditional justice system is not working, and they are having to take responsibility for all of that. So we have said that there's no reason why that should not be employed, even with serious cases, if properly managed. And that we will always be employed the same sort of methods, mediation, facilitate dialogue between offender and society, and addressing the root cause of that radicalization and developing strategies for rehabilitation. That is what it's all about. So it's very deep. And it goes to the length of your understanding, appreciation, and your flexibility of mind, open-mindedness towards the concept, and it will help, especially when we are addressing the root causes that we have within our justice system. And that's why some of us are very passionate about it, that because we have seen a little bit of the rot that is going on within our criminal justice system, and we know that we must find an avenue to amend or to deal with those the challenges. Without taking much time, I'm getting to the end of it. And the challenges where it applies in serious offenses is the fact that the critics are saying that such crimes of such magnitude demand a more punitive response to deter future acts, and that implementing this could require, but then we're saying it only means that you require a delicate balance between restorative justice principle and the need for societal security. That needs to be at the back of our mind when we are applying the RJ to serious offenses, and not just rule it out completely. And then the next point is also that the transparency and accountability process of the RJ is what is more important when it comes to serious crimes. Public safety is definitely number one, and that the RJ mechanism is not compromised the justice as a crucial factor. So we must strike that balance of confidentiality in RJ proceeding, and the public's right to know also is also those are all that it takes in the implementation of this. So, but it must be approached cautiously. So this is like almost a second tier level when we talk about serious, but we need to discuss it so that from onset we don't go back home to say restorative justice only applies to minor offenses, which is why I've taken time to show that this could be a larger concept than just dealing with those petty minor offenses, assault. No, it is a huge issue that needs to be institutionalized, and that's what we are preaching for all of us as we proceed after these many others presentation. So balancing of that societal and the effectiveness of these approaches in serious crime is still also a major debate, and you see people writing theses and dissertations on this restorative justice. It's a beautiful area which you can also get funding for if you are doing your postgraduate. That's an expo. So the gains in serious offenses is that it contributes to victim satisfaction, and all the rest of reduces recidivism, and particularly where offender expresses genuine remorse. And that's the key factor. And it takes a huge facilitator to be able to appreciate that. All right, so I'll have to summarize in 5 minutes. I added 2 minutes because of the initial 2 minutes that I was taking. So the critics will say, not approachable, not suitable for all cases, especially those, but the proponents will say that, listen, we have said it can never lead to a more compassionate and sustainable form of justice if well articulated and more institutionalized. And okay, let me move forward as we speak so that we have a little bit of idea in terms of how does it happen in practice. So it kickstart with the free consent, as I've indicated, as the primary criteria to kickstart the process by way of the victims expressing that they will be able to, and who initiate that. It could be anyone. It could be the court. It could be the law enforcement agencies when they decide and assess their evidence again, they can also be rest assured that they can start that and approach a victim, whether they will be willing to do that. Facilitator's role is very, very important. I've said it, impartial third parties, and they play the major role, apart from the administrator in at the center, who is organizing the whole day, conferencing, all that. The RJ will not work except you have trained facilitators, just the same way you have arbitrators in the civil. So I'm hoping that there's a lot of work being done by the college as well in relation to this area, training people to become a accredited facilitator. You will have to have a safe space that accommodates all those vulnerable persons. Most of them will be vulnerable persons, children, mothers, victims of this, that, they are all vulnerable. So you need to have a very good space for those conferences, and not the same way that you have it at the police station, where everyone is just, congregating around the same table, taking statement here and then. Language, you will always have to be prepared for interpreters and the rest of it. There's a lot of preparation being done for this to make a success of it. Training and retraining is the requisite, and that flexibility and the need for closure is what the essence of the RJ is all about. Whether how many conferencing and sitting arrangement you have, there must be an end, not like on the open-ended one in our traditional justice system that we have. So some form of it is usually the process is apart from the center, which have also RJ Center, and we are happy that in the FCT we have managed to institutionalize that, is at the Gudu High Court. And the director is here sitting, I'm sure she's hiding. Then we have what sort of conference? We have victim offender mediation, which involves only victim and offender. We have circles, which is a larger one, which is offender, victim, and sometimes the community and government representatives most times. And then obviously conferencing is much more larger, which is also all that people are involved with. Those are the key sort of process and procedure that's employed. And who can refer, I said, the police at the pre-charge stage, post-charge Ministry of Justice Department, and then post-charge also the court itself could refer. And these are the principles for referral. In the interest of the protection of the society, consider appropriate needs of the victim, accept responsibilities, and obviously the consent and the willingness and all of that. And so let me just go finally to the, the outcomes are there, that restitution, financial compensation, community reconciliation, and all of that, and sometimes educational program. And the benefit, again, is the same. And the challenges is what I will be closing on. And that is the institutionalization I've been mentioning. Institutional framework. We have protocol, we have manual, training manual for facilitator, we have all sorts of things that we have already done for the FCT, which we borrow from Lagos. And lack of awareness in terms of is also one of the major drawbacks. This is a good forum that we are also initiating, and we keep doing that. The NGOs and the communities need to be more involved. So government needs to support this process and not consider it to be a deviation from the traditional justice system, but also that is part and parcel of the traditional system. And there are all those people forming opinions, even before you understand the concept, and you said, no, this is a foreign, let's move away from that and face it that we need to do something to reform our criminal justice system and all that, and lack of legal precedent. It's unlike what you'll be citing cases and the rest of it. These are all new and peculiar cases across everyone. I think that is what it is. How we recommend that is what we will do to support all those challenges is what we have said, to cultivate a restorative culture, promote multi-agency cooperation, access to restorative service itself, and individual institute preferences. These are all attributes in terms of practice, and you will get to know that. That might not be a bit of relevant, but I've said it all that most important. It is actually expensive. And not too expensive, but we have the beauty of it is that we have development partners who are very much all over the world. You need to research. There are development partners who are supporting this noble cause. And whether you as a academician or you are a practitioner, there's always room for support and you can make that research. And we can also I can also point one or two places that would be of support, who are ready and on the ground to help establish restorative justice in Nigeria. And so that is where I say that it's all in our hands to ensure that we'll all put hands together to make this a reality and support and ensure that that path of our reform for the criminal justice that we're constantly looking out for becomes a reality. And this offers one of those outlets for that. Thank you very much for listening once again.
Thank you very much, sir. And I'm sure that warm applause expresses the appreciation for the rich presentation that we have just enjoyed. And some of the things I took note of was how he said restorative justice, seeks to address the root cause of harm for long-term resolution. And then he spoke about healing, accountability, restoration of relationships, and all of those. And I'm particularly happy for the mention of how it also helps to ensure the respect for the human dignity, which oftentimes is maybe inadvertently, but oftentimes abused in the course of criminal justice administration. Thank you so much, sir. We are most grateful. Please, another applause for him. Before I proceed to invite the next speaker, please permit me to recognize the presence of the representative of the Honorable the Attorney General of the Federation and Ministry of Justice, Mr. Lateef Fagbemi, Senior Advocate of Nigeria, ably represented in this hall this afternoon by Mr. Rotimi Oyedepo, SAN. You're welcome, sir. We also have some sort of judicial blessing with the presence in this room of the Honorable Justice M.E. Aneni of the FCT Judiciary, FCT High Court. And also my Lord Honorable Justice Keke Meke. You're welcome, sir. We're honored by your esteemed presence. Thank you very much. So next up for his presentation is the Director Legal, Economic and Financial Crimes Commission, Mr. Sylvester Tahiru, Senior Advocate of Nigeria.
The President of the College of Arbitrators of Nigeria, co-panelists, my noble lords, distinguished guests, ladies and gentlemen, good afternoon. I plead to stand on the protocols that has been established before now because of want of time. And I'd like to go straight to the paper. Like it was said before now, I'm representing the Executive Chairman of the Economic and Financial Crimes Commission, who is unable to be here present because of other pressing matters. Without much ado, I'd like to speak to the paper as it is. Now, the topic for presentation is restorative justice, the role of alternative dispute resolution in criminal administration in Nigeria. Now, the topic for discussion, I must say, is both relevant and timely, as it will be very educative and eye-opening, particularly to law enforcement and anti-corruption agencies like the Economic and Financial Crimes Commission, whose main mandate is the investigation and prosecution of economic, financial, and other related crimes, as stipulated by its Establishment Act 2004. The function of the EFCC and its special powers are respectively copiously provided for in Section 6 and 7 of the Establishment Act 2004, whereas Section 13, subsection 2 of the Act creates the Legal and Prosecution Department, whose primary duties inter alia is prosecuting offenders under the Act. Now, to the layman and the less or uninformed members of the citizenry, given the above topic, which is importing the concept of alternative dispute resolution in criminal matters. Now, to the layman, the nagging question would be, how is ADR, or how is the ADR mechanism relevant in criminal justice administration? Put differently, the question would be, can alternative dispute resolution be employed in settling criminal cases? And I think some of the answers to this nagging question has been offered by the first presenter. So if you have followed the presentation, that question might have one way or the other been answered. That is the question that law enforcement agencies, LES, including the FCC, are waiting with bated breath to hear the answer. We hope the organizers and facilitators of this seminar will provide the needed answer. We are not the experts. We are just here to listen to it, because ultimately, at the end of the day, if it is workable, it is to law enforcement agencies that you will be asking that, oh, we employ the mechanism of ADR in criminal justice administration by employing the option of restorative justice. From the above captioned topic, it is pertinent at this stage to appreciate two principal components of the topic, namely restorative justice and ADR, that's alternative dispute resolution. Then we now started by asking the question, what is restorative justice? Restorative justice, according to definitions from Oxford Languages Online, means or refers to a system of criminal justice which focuses on the rehabilitation of offenders through reconciliation with victims and the community at large. And that point has also been made, that it involves three parties: the offender, the victim, and the society at large, since it is crime that is involved. The guiding principles of restorative justice in crimes where the concept is used are: 1, crime is an offense against human relationship. Victims and the community are central to justice processes. The first priority of justice process is to assist victims. That's very central to the concept of crime as well as restitution. The second priority is to restore the community to the degree possible. The offender has personal responsibility to victims and the community for crimes committed. Stakeholders share responsibilities for restorative justice through partnerships for action. And lastly, one of the fundamental principles is that the offender will develop improved competency and understanding as a result of the restorative justice experience. The primary stakeholders involved in the criminal justice system, from what has been said above, who would benefit from restorative justice principles include the crime victims, prosecutors, defense attorneys, the judiciary, law enforcement agencies, elected officials, service providers, and corrections officials, that's the prison officials and personnel. And we refer to the National Institute of Justice, NIJ, their publication of 1998, which is a body under the auspices of the Department of Justice in the United States. The 5 components of restorative justice and what are known as the 5 R's of restorative justice are: relationship, respect, responsibility, repair, and reintegration. In other words, a successful restorative justice builds relationships, it ends or restores respect, it creates responsibility, repairs tattered relationships between the offender and the victims, and reintegrates the parties, that is the victim, the offender, and the community. So once it is well employed, just like in civil proceedings, where if you allow the parties to litigate from beginning to the end, at times after so many years of litigation, rancor is created, hatred is created, discords and the rest. But where ADR is employed, whether in civil or criminal proceedings as a means of resolution of disputes, it cements relationship between parties. Instead of them going, each one of them going their ways, it tatters, and as enemies, it kinds of reintegrates relationships. It bears mention that there are three main types of justice, namely distributive justice, retributive, and restorative justice. Restorative justice as a concept has already been defined above. Retributive justice essentially refers to the repair of justice through unilateral imposition of punishment, whereas restorative justice means the repair of justice through reaffirming a shared value consensus in a bilateral process. So in retributive justice, somebody takes the law into his own hands to inflict harm on the other as a means of exerting vengeance from the offender, whereas the other concept is bilateral in the sense that in restorative justice, there is a dialogue. You talk. You have wronged me. How do you compensate me? How do you put things right? So it means there's a bilateral process. Unlike in the other one, unilateral, somebody who feels offended inflicts harm or exacts a retribution against the offender. On the other hand, distributive justice is defined as perceived fairness of how rewards and costs are shared by or distributed across group members. Example, some workers work more hours but receive the same pay. Group members may feel that distributive justice has not occurred. Now, importance of restorative justice. Restorative justice can be important for the community. It can resolve conflicts and prevent them becoming crimes. For example, it could be used for antisocial behavior or neighbor disputes. The restorative practice allows people to see the consequences of their actions on the community. So that's one takeaway from it. Then the other component we want to speak on, because the paper consists of two main issues, that's restorative justice and ADR. So the next thing is alternative dispute resolution. The Wikipedia Oxford Languages Dictionary Online defines ADR to mean or refer to the use of methods such as mediation or arbitration to resolve a dispute without resort to litigation. Put differently, ADR refers to any means of settling disputes outside of the courtroom. The most common types of ADR for civil cases are mediation, settlement, conferences, neutral evaluation, and arbitration. ADR, or external dispute resolution, typically denotes a wide range of dispute resolution processes and techniques that parties can use to settle disputes with the help of a third party. They are used for disagreeing parties who cannot come to an agreement, sort of litigation. The importance of ADR is now pivotal to the Nigerian legal system and has been embedded in the Constitution of the Federal Republic of Nigeria, 1999, as amended, as a foreign policy objective in settling international disputes. And we refer to Section 19, paragraph D of the Constitution of the Federal Republic, which provides for the settlement of international disputes by arbitration, mediation, conciliation, negotiation, and adjudication. But of course, that applies mainly in civil proceedings. Why ADR? ADR gives parties in dispute the opportunity to work through disputed issues with the help of a neutral third party. It is generally faster and less expensive than going to court. When used appropriately, ADR can save a lot of time by allowing resolution in weeks or months compared to court, which can take years. Then alternative dispute resolution mechanisms in criminal justice administration, which is the core of the discussion. As it seems obvious from the above discussion, the vehicle of ADR is most commonly employed in the settlement of civil disputes between parties, unlike in civil cases where parties can adopt any of the ADR mechanisms, namely arbitration, mediation, conciliation, negotiation, or adjudication to settle disputes. In the administration of criminal justice, such methods are not common. Rather, the alternative to a full-blown criminal prosecution, whose end result or goal by the prosecution is normally to secure conviction and sentence of an accused person, the alternative is plea bargain or compoundment of offenses, which are provided for statutorily under relevant legislations, which are discussed hereunder. Then we start with the plea bargain. We started with a definition of what a plea bargain is. Section 494, sub 1 of the Administration of Criminal Justice Act 2015, which is the interpretation section, defines the term plea bargain as the plea bargain means the process in criminal proceedings whereby the defendant and the prosecution work out a mutually acceptable disposition of the case, including the plea of the defendant to a lesser offense than that charged in the complaints or information, and conformity with other conditions imposed by the prosecution in return for a lighter sentence than that for the higher charge, subject to court approval. So plea bargain is statutorily provided for. It's not something that somebody can do on his own. And of course, you know that there is a wide misconception of what plea bargain is all about. When members of the public hear that a case has been resolved through plea bargain, the normal accusation is that the prosecution, the judiciary, and every other person has compromised the case. But that is based on ignorance, because it is legal. It is provided for under the law, as we shall soon see. Plea bargain in law is the practice of negotiating an agreement between the prosecution and the defense, whereby the defendant pleads guilty to a lesser offense, or in the case of multiple offenses, to one or more of the offenses charged in exchange for more lenient sentencing, a recommendation of a specific sentence, or a dismissal of other charges. Now, supporters of plea bargaining claim that it speeds court proceedings and guarantees a conviction, which is true. If you are employing the process of a plea bargain, cases are known to have lasted for half a decade or even more than a decade when you are employing the process of a full-blown trial, because you have to call witnesses. Some of them may be very many numbers, 10, more than that, and we also know the strategies that defendants do employ to make sure that trials are prolonged for as long as possible, just to frustrate the case from going on. But while you employ the vehicle of a plea bargain, the process is curtailed in the sense that it doesn't take a long time. Now, while the supporters of plea bargain claim that it speeds court proceedings and guarantees a conviction, whereas opponents of the plea bargain believe that it prevents justice from being served, which is also true. I recall when one police pension defendant was convicted by the court, there was around 2013 or so. It was so serious that it hit the nation. So the prosecution had to appeal against that decision. The Court of Appeal reviewed the sentence. In that case, anyway, there was a full recovery of the process of crime. But because it touched on a very serious subject, you can imagine police pension, something that should go to for the benefit of widows, orphans, and those who are deceased, dependents of the deceased. Somebody just cornered everything, bought properties here and there. Recoveries were made, but in the course of prosecution, like the sentence was a slap on the wrist, and it provoked the entire nation. An appeal was lodged against that sentence and conviction, conviction and sentence, and the Court of Appeal reviewed it. After the review, the defendant or the convict appealed to the Supreme Court. In fact, the Supreme Court not only restored it, but they also increased the sentence. So that's how bad some people feel about the concept of plea bargain, that it is not easily swallowed, especially in our plan, where it is not well known, the concept of plea bargain, other concept that appears to give a leeway to criminals to escape justice. Now, I mentioned the various facets of a plea bargain. It could be either a charge bargain, sentence bargain, or it could be a count bargaining. And each is explained there. In charge bargaining, the defendant agrees to plead guilty to reduce charges, e.g., aggravated assault rather than attempted murder. If somebody is charged for attempted murder, of course, at the end of the trial, the sentence, if the accused person is found guilty, the sentence will be higher. But if he goes into a bargain, on a charge bargain, it mitigates. So instead of attempted murder, it could be aggravated assault. Now, sentence bargaining involves assurances of lighter or alternative sentences in return for a defendant pleading guilty. One of the most visible forms of sentence bargaining occurs when defendants plead guilty to murder in order to avoid the death penalty. So if somebody is charged for like a culpable homicide punishable with death, like applicable in the penal code in the north, or you are charged for murder as in the criminal code in the south, you can go for a sentence bargaining. Charge bargaining. Sentence bargaining, in which case it can be mitigated. Sentence bargains also occur in less serious cases, such as pleading guilty to a charge in exchange for a sentence of time served, which generally means that the defendant will immediately be released. The third type of plea bargain is count bargaining, in which defendants who face multiple charges may be allowed to plead guilty to lesser counts. Maybe you go to court with a 50-count charge, or 20-count charge, or 10-count charge. In a count bargaining, it can be reduced drastically, maybe from 10 counts to 2 counts or more, or less. So the third type of plea bargaining is count bargaining, which defendant may be allowed to plead guilty to fewer counts. The identical to may be any charge or charges in exchange for a guilty plea on the remaining charges. Because count bargaining applies all defendants who face multiple charges, it is the least common form of bargaining. Generally, a plea bargain allows both parties, that's the trial, and may allow the accused to avoid the risks of conviction at trial on a more serious charge. A careful consideration of plea bargaining, as explained above, would reveal that in a plea bargain, or in a plea bargain agreement, the accused or defendant is not entitled to a complete exoneration or acquittal from the alleged offense. Contrary to misconceptions by the uninformed, an accused person following a plea bargain does not get a discharge and acquittal. Rather, the accused receives lighter sentence. In any event, the accused must suffer a conviction and sentence. In offenses affecting property, there must be a restitution or a payment of compensation as the baseline for plea bargain. And that's what we practice, like even in EFCC. When you are accused of a financial crime and you apply for plea bargain, it's not just that you are asked to plead to a lesser offense, but the process of crime must be restituted, which is a condition precedent. Now, the whole concept of plea bargain is stipulated or codified under Section 270, Sub 1 to 18 of the Administration of Criminal Justice Act 2015. And under that section, elaborate provisions are made concerning plea bargain. Generally speaking, it is under the control of the court because it is predicated upon a charge, and the charge is before the court, so the court has wide discretion in moderating the kind of bargain that is there. If it is ridiculous, the court will not tolerate it. Now, as a form of restorative justice, we refer to some sections. We refer to some subsections under ACJA, which seeks to take interest of the accused person, the victim in the plea bargain agreement. For instance, Section 20 Sub 1 empowers the prosecutor by way of discretion to either receive, the application can be either from the defendant to the prosecution, or the prosecution itself can offer a plea bargain proposal to the defense. But most often than not, it is the defendant, of course, that proposes. And when we evaluate and see the merit, once some conditions are met, restitution are made and the rest, we can accept it. Then subsection 2 of Section 270 permits the prosecution to enter into a plea bargain with the defendant with the consent of the victim or his representative during or after the presentation of the evidence of the prosecution, but before the presentation of the evidence of the defense on 3 conditions. Namely, it could be insufficiency of evidence to prove the offense, cooperation by the defendant with the investigation and prosecution of the crime in the case of conspiracy by providing relevant information that can be useful in convicting the co-accused. Then one of the other conditions which is very germane is the restitution to the victim or to his representative. We should also take note of the fact that the prosecutor may only enter into an agreement contemplated in Section 270 Sub 3 after consultation with the investigation officer of the case and the victim or his representative. So it's like a tripartite thing. The investigator who investigated the case knows his case. He transmits his duplicate case file to the prosecution, who vets the file and comes up with a charge. But in doing the plea bargain, the very vital person in the entire process is the victim. So all of them have to be on the same page. Then, with respect to the plea bargain, it is important to note that the prosecution is empowered to take reasonable steps to ensure that any money, asset, or property agreed to be forfeited or returned by the offender pursuant to a plea bargain are transferred to or vested in the victim, his representative, or other person lawfully entitled to it. So, if in a plea bargain agreement it is agreed that, the process of crime should be restricted to the victim, and the accused person is unable to do it before, it is the business of the prosecution to make sure that that is done. And I also refer to Section 11 of the Advanced Fee Fraud and Other Fraud-Related Offences Act, which even gives the prosecution the power to enforce that agreement. If there is any plea bargain, it can be enforced as a judgment in a civil case where the court makes an order of restitution or compensation. It is the business of the prosecution to do that. Then the other aspect of what seems to be an ADR in criminal proceedings is also compoundment of offense. And I refer to section 14 sub 2 of the EFCC Establishment Act. And that power is given under section 14 sub 2, which is that the prosecution can can compound an offense. And one thing I need to highlight here or to emphasize here is that at times people think in compounding an offense, maybe I'm alleged to have misappropriated, let's say, 5 million naira. Other, if I'm a government official, I misappropriate 5 million naira. They think the payment of 5 million naira is the compoundment. Yes, it's part of the process of the compoundment. You must restitute the process. But what section 14 sub 2 means is that the commission may accept such sum. Just like after the court has found somebody guilty, you have restituted the process of crime, the court can still go ahead to impose a fine. So the equivalent of that is what section 14 sub 2 of the EFCC Establishment Act says. Even after the restitution of the victim, if you are compounding an offense, the commission may accept such sum as it deems necessary, which is the equivalent of the fine. And that amount by section 14 sub 3 is paid into the Consolidated Revenue Fund of the Federation. And I refer to the definition of the word compound and the concept of compoundment of offense as decided by the courts in the cases that are referred to there. Now, from the above analysis of the two methods, of the two mentioned concepts of plea bargain and compoundment of offense, provided under the Administration of Criminal Justice Act as well as the EFCC Establishment Act, it can be seen that there is a restricted or limited sort of alternative dispute resolution, ADR, and restorative justice in criminal proceedings, in the realm of criminal law, unlike in civil law where ADR is fully enforced as a means of dispute resolution. Now, concluded by saying that it is hoped that this seminar by the College of Arbitrators of Nigeria would shed light as to how restorative justice and ADR can be brought to bear in criminal administration in Nigeria. But like I said, Mr. Suleiman, in his presentation, has answered some of the questions that was agitating our mind. So with that, I thank you for listening.
Thank you very much, sir. I think one of the things to note is the response we got from him to the question posed by the first speaker, who had asked, in the event of ADR in criminal justice administration, would it become a discharge and acquittal or not? And in his response, he notes that though ADR plays a role in criminal justice administration, he mentioned two mechanisms, being plea bargaining in their different forms, and of course compounding of offenses. And then he answers to say it does not and will not transform to a discharge and acquittal. But of course, maybe a lesser sentence and all of those. We are most grateful for that presentation, sir. Please, another warm applause for him. And now we'll go into the last presentation for the day. Of course, you can save your questions and your comments for later, because our speakers are still very much around and will be taking those questions as the need arises. Our last speaker for today is the president of the Mediation Training Institute, an astute ADR practitioner, the very ambassador Segun Ogoniaunwo. Please, sir, the microphone is yours.
Thank you. Thank you so very much. I appreciate you. I would like to thank the President and all the members of Council this special program. Special regards to my lords and very distinguished legal luminaries in the house. Dr. Rosemary Chikwendu, thank you for the recommendation. I appreciate you. As an ADR practitioner, I believe that ADR thrives on possibilities. So please permit me, instead of standing on existing protocols, permit me to sit on existing protocols. Thank you. When I got the topic, I was wondering, what do they want me to talk about? For more than 15 times, I looked at the topic. So if it's the same topic that's been sent to other facilitators, then maybe they want me to look at it from another perspective. Because whatever I'm going to say about restorative justice generally would have been things covered by the previous speakers. So I'll start with two quick experiences, life experiences. I was invited to Goza. Goza is 20 kilometers from Sambisa Forest. I received calls from all over the world. What are you going to do there? Mr. Yaya DBC, who married from Goza, called me and said, I married from Goza. Everybody I know from Goza no longer lives in Goza. How much are they going to pay you? He didn't know that the only condition I gave UNDP for going to Goza was that I should not be paid. Why? When I read about what happened in Goza, I discovered that those who were shot were people who were running away from Goza. People who were running for that were the ones that were. Those that they met at home, the Boko Haram adherents, did not want to waste their bullets. They were slitting their throats. They didn't want to waste bullets. So going to Goza to make money for me would amount to blood money. So the only condition I gave was I should not be paid. The manager of the Danish refugee camps, when he heard that I said I was going there, I wouldn't be paid, made arrangement for the flight from Abuja to Maiduguri and the helicopter from Maiduguri to Goza. In Maiduguri, we are looking at how we would go and empower those there, the NGOs and whatever, even empower the soldiers. This manager, instead of looking at the documents, he was looking at me. It then occurred to me what may be on his mind, that this may be the last time. So I smiled and I said, well, the depth of a man's passion is determined by his willingness to die for whatever it is that he's living for. I'll take that again. The depth of a man's passion is determined by his willingness to die for whatever it is that he's living for. We got to Goza. That night there were 3 bomb blasts. In the morning, the head of the humanitarian hub called everybody together. Mr. Shegun, we didn't see you last night. I said, what for? What were you looking for? Didn't you hear the bomb blast? I said, I did, and told him the timings. So how come he didn't come out? I said, my training is different. If you can hear the bomb blast, that means wherever you are is safe. Because you can detonate the bomb here with the mind that people will rush out and they just, as a meeting, talking about forgiveness and trying to get the Boko Haram adherents who have repented. I was excited talking about ADR. One of their chieftains in the committee called me aside. I said, what are you talking about? Forgive who? Then in the past, some came back, said they had changed, only to come and look around, inspect, went and then came back to cause more. We have laws. We have laws. When people commit crimes, there should be consequences. I'm talking about ADR. Well, it's okay when you apply to criminal justice. What happens at the end of the day? There may be a lot of recidivism. People saying, someone who steals money. In Delta State, a man was caught with a badge. The content was worth 200 million naira. After the FCC came in, because at the end of the day, was asked to pay 17 million. Not 170, 17. So His Excellency was saying that we don't seem to understand plea bargaining. I think we do. It is the application that we don't seem to understand, though. We don't understand the application. How will a man steal my car? The man is now called, say, oh, God, wait, goes into the trunk, brings out the spare tire, say, oh, God, you can roll this one home. And I will allow it to not happen. If somebody steals my shirt, his coat, he says, oh, God, no vex. He removes the button, gives me and goes. It is sad. But let's look at some areas that may help, because like we've been told, is already in our laws. Section 17 of the Federal High Court, for instance, is even tagged reconciliation in civil and criminal cases. It offers an entry point for applying ADR principles in criminal cases. The section provides that in any proceedings in the court may promote reconciliation among the parties thereto and encourage and facilitate the amicable settlement thereof. Let's look at the next two slides. Adopting the literal rule of interpretation, promoting reconciliation among the parties to a criminal case would involve victim-offender mediation, and facilitating amicable settlement of a criminal case encompasses plea bargain. However, the extent to which this provision avail an offender who is charged with a felony or capital offense is not clear, as amicable settlement of such cases, which will be tantamount to an acquittal without trial, a judicial prerogative which erases any criminal record, will be clearly contrary to public policy. So we need to be careful how we apply ADL. But now we're talking about restorative justice. United Nations intervention in 2002. It was in the course of the great dissatisfaction and frustration with the former justice system that United Nations Economic and Social Council in 2002 adopted the basic principles on the use of restorative justice programs in criminal matters. Well, it has been defined, but let's just look at it again. A system of criminal justice which focuses on the rehabilitation of offenders through reconciliation with victims and the community at large. It's about the victim, the offender, the community. So there must be accountability. We must talk about community safety, competency development when we apply restorative justice. People who have the capability to make a difference. In the Northeast now, we are talking about providing them with conscientization. Are we aware that some people who killed the soldiers, some of them have now been absorbed into the Nigerian army? It is sad. So Mr. Amos is killed. His wife and children are suffering. Mr. Abel, who killed him, is now replacing. It is sad. There must be consequences when people come to crime. We have laws. We have laws. Let's go on, please. We have the definition, we have spoken about it, but the book, the little book of Restorative Justice by Howard Hare, says that restorative justice is a process to involve, to the extent possible, those who have a stake in a specific offense and to collectively identify and address harms, needs, and obligations in order to heal and put things as right as possible. Even in a murder case, sometimes it may apply. The great Justice Oputa, what did he say? Justice is not a one-way traffic. It is not justice for the appellant only. Justice is not even only a two-way traffic. It is really a three-way traffic. Justice for the appellant accused of a heinous crime of murder. Justice for the victim, the murdered man, the deceased, whose blood is crying out to heaven for vengeance. And finally, justice for the society at large. The society whose social norms and values had been desecrated and broken by the criminal acts complained of. Fundamental principles of restorative justice. The primary determinants of justice are the interest of the victim, the community, and the offender. Punitive actions do not always serve those interests best. Crimes are against individuals and, to some extent, communities, not against the state or the law. Not against the state or the law. But why do we always say it's about the state or the law? It makes some sense because we all have contributed some of our rights to the state to prevent people from resorting to self-help or taking laws into their hands. But generally, when you arrest a man, how does that benefit the person who is a victim of a crime? But generally, there are guiding questions for criminal justice. We talk about what laws have been broken, who did or omitted to do what, What do they deserve? And then we also talk about, let's take the fourth one. Sorry, there's another. Yeah, what do they deserve? Then for restorative justice, we are talking about who has been hurt. You see, it's double. What are their needs? Whose obligations are these? What are the causes? Who has a stake in the situation? What is the appropriate process to involve stakeholders in an effort to address causes and put things right? I'm rushing because when I got the invitation, there wasn't any timing. And I requested today, I'm prepared for, I told the person I sent me, I can speak for 10 minutes, I can speak for 2 hours. Let me know how much time. So I've been told here now, I'll do this in 20 minutes. So let's see how far we can go. The philosophical roots of restorative justice. Humans are capable of reform. Is that always true? Generally so. Well, there are some people. Offenders should have the chance to make amends for their crimes to victims and take responsibility for their offenses. If an offender does make amends, then he or she should be reintegrated into the society. Moreover, offenders must also be protected from retribution, so that society as a whole does not suffer from norms of vengeance taken. Especially when we have violent conflicts. When there's history of violence, there's this theory that when the history of a conflict is violent, it helps to perpetuate the divide and make more entrenched the dehumanization process. I'll take that again. When the history of a conflict is violent, that's a tendency to perpetuate the divide and make more entrenched the dehumanization process. If youths from another community attack my community and they kill people, I was able to escape. I believe that my escape was by divine providence. What will I do? I go and mobilize and command. If when they were trying to kill my cousin, they cut his hand and I catch someone from the other community, is it only the hand that will cut? And that's why by all means we must try to avoid history of violent conflicts. There will be that vicious circle. And we need to be careful about that. Victims need a chance to confront offenders directly. Victims should have some say in the response to the crime they have suffered, generating options for the offender to make amends and pointing the path toward forgiveness. Victims need a chance to confront offenders. Sometimes it provides closure. A young lady who is raped in the neighborhood, who is afraid of all men, needs to know the person who actually committed. It provides a closure for her. Community members should also have a chance to participate in the discussion of crimes. Government's primary role is to preserve a just public order of the system, while the community's role is to build and maintain a just peace, daily behavior. The 4 arrows of restorative justice, as against the 4 pillars of criminal justice, the 4 arrows of restorative justice, otherwise known as the key values of restorative justice, are reconciliation, restitution, reintegration, and restoration. We have models of restorative justice. We won't have time to look at them, but I'll be sending these slides forward so that we don't take too much time. But look, let's just look at the headings. We have the state-centered models. We have the community-centered models. We have the victim-offender mediation, where you bring the victim and the offender. Sometimes there's a screen to prevent direct contact. So the person, this person. So a man, for instance, who killed the breadwinner, when he sees the wife and the children, there's a way it can elicit in him some remorseful feelings. It helps sometimes. Conferencing programs, community or local government hosted discussions. Panel models, assistance programs. Now, let's look at this. I think it's instructive. The Nigerian Correctional Service Act 2019, Section 43(1) says that the Controller General shall provide a platform for restorative justice measures, including victim-offender mediation, family group conferencing, community mediation, and any other mediation activity involving victims, offenders, and where applicable, community representatives. Number 2 of that section says the correctional service shall liaise with the court and other relevant agencies in the provision of these measures under subsection 1. Restorative justice services may occur at 4 levels: at pre-trial stage, at trial stage, during imprisonment, and at post-imprisonment. It's nice to think, how is it possible to have it at all this levels, especially at the post-imprisonment? We'll be talking about it when we have the question sessions. And then number 4 says that the correctional service shall appoint supervisors to monitor the implementation of measures and services stated under sections 1 and 3. So I'm happy that we have that center here in Abuja. And now that we're talking about arbitrators who will be taking care of restorative justice, and we're talking about money. Money is good, but money must be secondary in the things we do. I repeat that for emphasis. Money is good, but money must be secondary in the things we do. Let's see to what extent we can add value to the society. In conclusion, as against the popular criminal justice system that focuses on punishing offenders, restorative justice focusing on repairing the wrong caused by criminal behavior. Restorative justice involves the victim of a crime, the offender, the social networks, justice agencies, and the community at large. Restorative justice adopts victim-oriented problem-solving approach to crime. It emphasizes restitution to victims of crime. Restorative justice has been in our traditional systems, and there's great need to adopt it as the Nigerian Correctional Service has done. I was talking about after imprisonment. In 2 weeks' time, in Ebonyi State, there's going to be a conference of attorneys general from the southeast. They are focusing on how to do this. And part of the proposal is to have farm settlements. Based on the different crimes, somebody can be out of and then go there to serve. The produce, the government will give 60% of it. They'll be saving it for the person. So while you're even in prison, you know there's a project that can fall back, or you become the full owner of it when you come out, employing people, and can become more productive to the community. The great Emerson says that we shall meet if we are related. That I'm here today shows that we're related, and I appreciate you. Thank you. Thank you.
Thank you so much. We appreciate you right back. And I speak for the college and all other participants, right? Absolutely. Thank you very much, Ambassador. And that was our last speaker, waxing quite philosophical there. And I like the emphasis on the human. All of the angles to ADR centered on the human. Opportunity to make atonement for whatever their offenses are. Opportunity for victims and maybe their families to gain closure. Opportunity for reintegration, even for a better society. All of those, I'm sure we all agree, cannot be overemphasized. Thank you so much. We most appreciate you, sir. So, and thank you too for all of you for relaxing and patiently waiting. As I had promised earlier, and as was advertised, of course, we have only 3 speakers and we're done taking our speakers. But before we allow you the opportunity to lend in your contributions to this conversation, please permit me to welcome to the microphone for a message for us from the Honorable the Attorney General of the Federation and the Minister of Justice, Mr. Lateef Fagbemi, SAN, his representative, oh, sorry, I had a correction from the audience, Chief Lateef Fagbemi, SAN. My apologies. So, of course, ably represented by the Special Assistant to the President on Financial Crimes and Public Prosecution Compliance, Mr. Rotimi Oyedepo, Senior Advocate of Nigeria. Please a warm applause for him.
The President of the College, the most distinguished Senior Advocate of Nigeria, the discussants and resource persons here present, my lords here present, the distinguished participants. Let me quickly say that in Yoruba land, when you are a prince, you can't be a chief. So my direct boss is a prince from the north central part of Nigeria, which is Kwara State, and by virtue of his birth, is eminently qualified to be the king of the town. So no one can confer chieftaincy title on it. Thank you. He had wanted to be here personally, but he was unable to make it. So he has directed me that I should come and represent him, and he has a message as the MC had indicated, and I'm just going to proceed. It gives me the pleasure to be invited to participate in this very important one-day seminar and dinner with the theme Restorative Justice, the Role of ADR in Criminal Justice Administration in Nigeria. This seminar could not have come at a better time considering the ongoing effort to reform the administration of criminal justice in our country through deliberate promotion of alternative dispute resolution mechanisms in the administration of criminal justice. As we are aware, the Administration of Criminal Justice Act 2015 was a conscious attempt to address the numerous challenges bedeviling the administration of criminal justice arising from undue delays, congestions of court docket, probation and non-custodial measures, as well as restitutions for the victims of crime. In clear terms, the ACJA 2015 provides for plea bargaining and plea generally under Section 270 to 271 of the Act. Section 270 empowers a prosecutor to receive and consider a plea bargain for a defendant charged with an offense either directly from the defendant or on his behalf, or offer a plea bargain to a defendant charged with an offense. The Act went to further spell out an elaborate guideline for the prosecutor to apply in plea bargaining a case. In order to consolidate the application of alternative dispute resolution in criminal case, my ministry has taken a cue from what Lagos State has done by promoting restorative justice in criminal justice administration. The development of the National Restorative Justice Policy, I take that again, the development of the National Restorative Justice Policy is emphasized as a comprehensive yet flexible policy which may be applied to all categories of wrongdoing. It holds the potential of profoundly impact the Nigeria justice system, ushering in a new era of fairness and inclusivity. The policy encourages the use of restorative justice process to resolve conflict and foster reconciliation. In broad terms, the objective of the National Restorative Justice Policy are, among others, to 1. Reduce recidivism, 2. Promote and protect victims' interest, 3. To promote peaceful coexistence in our community, 4. To reduce incarceration or custodial sentence, in our criminal justice system. And the last but not the least, increase public confidence in the judicial justice system. A robust implementation of the strategy is being developed to give effect to the restorative justice policy when approved by the Federal Executive Council. It is also our expectation that the various states in the Federation outside Lagos State will draw inspiration from the national restorative justice policy by adopting and adapting same within their states to promote alternative dispute resolution in deciding criminal matters. I therefore look forward to a productive engagement as we expand the frontiers of this very important and timely subject in our criminal justice administration. Thank you for listening, and God bless the Federal Republic of Nigeria. Thank you for inviting us.
Thank you very much, sir. And thank you particularly for that correction. So I shouldn't have taken the correction I got from the audience. And thank you very much, sir. I won't make that mistake again. So that was the representative of the Honorable the Attorney General of the Federation and the Minister of Justice, Prince Lateef Fagbemi, Senior Advocate of Nigeria. Of course, we heard from Mr. Oyedepo, SAN. Thank you very much, sir. We're grateful. Of course, dinner will follow shortly. So please relax. We'll have enough prepared for all of us. Before we go into getting your contributions, please permit me to welcome to the microphone for a goodwill message the Honorable Justice M.E. Aneni of the FCT High Court. Please, a warm applause for her.
Thank you. The President, College of Arbitrators, Nigeria, permit me to sit on already established protocol. I may borrow from him. Ladies and gentlemen, greetings to everyone. Before I proceed, I want to convey greetings from my Lord, the Honorable, the Chief Judge of the Federal Capital Territory, who actually wanted to be here, but for pressing official duties, he has asked me to felicitate with you and give you his good wishes, and thank you for the invitation to the FCT High Court. First and foremost, I was told a few minutes ago that I was going to give a goodwill message. Before then, I had written down some questions I wanted to ask. So I will just slot in one of them, if you permit me, before I go back to sit down. I really want to thank the organizers for this program, particularly this theme. In fact, when I saw it, I was thinking, at first I was like, restorative justice, I was thinking, what's this, And then I remember the little I knew about it. And I saw the criminal of ADR in criminal justice administration in Nigeria. I would want to say this is really apt. I won't say it's timely. In fact, it's more than timely. I know it has been on for some time. And I want to commend you because this, what you're doing is really needful. I would just give a small example of why I'm saying what I'm saying. There was somebody that was convicted for advanced fee attempt to obtain by false pretenses some years ago. And the last prison visit we had, I saw him while I was walking out. And he came to me and said, "Mommy, I'm still here." And you know the sentence for that offense? He attempted to obtain 350,000 naira. And you know the sentence? It's mandatory. Yes. So he came to me and I couldn't help it. I felt something. I just said, well, don't worry, just be good. Maybe something good will happen. They'll let you out. If we had employed something like this, probably something would have been done because he attempted to do a plea bargain 3 times in the course of the proceedings. I don't know. Okay, you were not in that matter. 3 times, but he reneged. Anyway, that's a long story. This is just to underscore the fact that what you are doing here is really, really needful. I commend your efforts. I wish you all the best, and I hope that you'll be able to bring more and more people in to follow your footsteps in what you're doing. Get the relevant stakeholders to support you. It is really necessary. We do need it, even in criminal matters, not just civil matters like we are used to. Like in the FCT High Court, we have ADRO, we have the multi-door courthouse, but it's just for the civil cases for now. I don't know if you have started in I don't think so. I'm not aware of that. It's just for the civil matters. No, I know you have started in FCT. I'm talking about our court, FCT High Court, yes. So far, it's for the civil matters. So if there is any way we can collaborate or anything you would like us to do to partner with you in this work that you're doing, this very, very noble work you're doing, just let us know. And His Lordship has asked me to let you know that we'll be willing and ready to collaborate with you. That having been said, I've just been given very short time to speak. Thank you very much. I wish you all the best, and God bless.
Thank you very much, my lord. Oh, sure.
Okay, I'll just take the simplest one. Now, I kept hearing victim, offender, victim, offender. At what stage do you determine who the offender is? Because usually when persons are charged to court, they are presumed innocent. So when they come to the court, it is after the matter is ended that the person is either found guilty or not guilty. So when you say the victim and the offender come face to face, so at what stage do you determine that the person is actually an offender? That is my question. I just want clarity on that, because if you're saying the person is an offender, because you say from the court, sir, you understand my question? Okay, so at what stage do you determine that the person is an offender? Because he's presumed innocent when he comes to the court. Thank you.
Okay, thank you very much, my lord. I hope the question has been taken note of. So please welcome also, my lord, the Honorable Justice Keke Meke, also of the FCT High Court, for just a few comments, please. A warm applause for my lord.
Thank you very much. Thank you very much. Thank you very much. This is a wonderful occasion, a wonderful event. But before I break protocol, I want to say the president of the college, College of Arbitrators, Nigeria, distinguished panelists, my lord, I take permission from you, ladies and gentlemen. I will not go on without acknowledging my lecturer in the ICMC. He taught me one of the beautiful topics in mediation. I'm talking about the Institute of Chartered Mediators and Conciliation, ICMC. Prince, thank you very much. I acknowledge you. Good, very good team. And the College of Arbitrators, or arbitration generally, very interesting, unique, and commendable. We are in the traditional system. The traditional system of adversarial method of administration of justice. But this new trend is growing very fast and is very interesting. But I want to add that before it goes full-blown, there is need for individuals to change their mindsets. There is need for Nigerians to change their mindset. The kind of mindset we have now is the mindset of an eye for an eye. You do me, I do you. So, if that is the mindset, it will be difficult. We have referred a lot of cases for arbitration. After about 6 months, 1 year, they come back and say, we are not settling. Please go ahead. It is very, very saddening. It's a very familiar terrain to me. Aside the experience acquired on the bench, having interpreted the Arbitration and Conciliation Act 1988, I commend you on this. I commend you on the signing into law of the new act on the 26th of May 2023. The new act titled the Arbitration and Mediation Act 2023. It promises to reform the arbitration law substantially. This is a major milestone and a momentous step for dispute resolution. Part 1 relates to what we all know, arbitration, while Part 2 relates to mediation. It is very, very interesting. Now, its objective essentially is to promote fair resolution of disputes by an impartial tribunal without necessary delay or expense. There is no doubt, you all know the High Court of the Federal Capital Territory. My learned brother has introduced it. I want to close by referring to a case that I handled. It's a case of issuing dot check, very common, you know. A lot of us must have handled cases like that before. He agreed. He took money from someone. He agreed. He signed the check. He agreed. He presented the check. He agreed that there was no sufficient fund in his account at the time the check was presented. Now, go and resolve this matter. Go make sure. I almost went into the area and resolved this matter. But he couldn't. I do not know whether it was the lawyer that was guarding him. Don't agree. Don't agree. This issue of don't agree. At the end of it all, he agreed, he took the money. He agreed. But there was no money to pay. So, after several adjournments, I had to do my job. And he was sentenced to, no option. He was sentenced to, I think, 2 years imprisonment. And then, thereafter, about a month after, I saw an application for bail pending appeal. What are you appealing again? That is why IDR and this restorative justice is very important. But unfortunately, our legal practitioners just like I am, are still archaic. They are not moving with the trend. They are still clinging to the traditional method of adjudication. This is a beautiful thing, reconciliation, conciliation, and promoting peace that God wants us to have. If only we can take cognizance of two very important principles, then we will be where the College of Arbitrators and the Institute of Mediation and Conciliation are taking us to. What are they? The Bible says that we should love the Lord with all our heart, our might, and our soul. And secondly, it's just like the first. Love your neighbor as thyself. If you love your neighbor as thyself, you will promote conciliation and reconciliation. And that I commend to all of us. And I want to say, thank you very much. You are doing very well in this. And by the grace of God, because I love what you are doing, I am an associate of, no, not, of the Chartered Institute of Arbitration, UK. I am also going to be inducted a fellow of the ICMC on the 28th, I suppose, of November 2023. Thank you very much.
I doubt there could have been a better speech with which to round off that session. Yes. By those comments, my Lord has actually cut out the role and the work of the college. And my Lord has called the college to action on the important duty of enlightening the public on the importance of ADR. And I'm sure that the college will rise to the billing in that regard. Thank you very much, my Lord. Okay, before we take reaction from the audience, please, in just max 2 minutes, permit me to take a photo session, just direct a photo session for our speakers and my Lord's present before they run along, please. Don't forget, dinner is served. You are not permitted to step out until after dinner. But please indulge me for just about a minute. Can we have our, yes sir, please. My Lords, can you please? The president of the college, sir. This is the chair of the planning committee, sir. And if we can just have Dr. Madumere join us quickly, and that will be it. Oh yeah, photograph. So this is the time for reactions from the audience. And I think it's also a good time to recognize the presence with us since afternoon of the Secretary of the MBA Abuja branch, Mr. Musa Isiaka. We're happy to have you in the house, sir. So can I get indications? Who has a comment, a question? Okay. And we're taking numbers 1, 2, 3, and 4. And I think that, okay, 5 and 6, that will be it. So in the order that you have taken your numbers, please let's have your question or your answer. And please, may I ask that our speakers, sorry, sirs. Yes, the audience will be, asking their questions or making their comments, and we will need you to make reactions to those. So if you could just take down whichever question or comment applies to your presentation. Thank you.
Good evening, everyone. I would just like to add that one group that is missing in this conversation are the legislators. because the new Arbitration and Mediation Act provides that parties, if the law provides for it, then you can mediate any matter. So the legislators now need to be aware that they can infuse in the laws this right of parties to choose mediation as a means of settling disputes. As you have said, the rules of court has already provided for it. So we need more robust engagement so that people are more aware of the choices. And so when in your presentation, you were very nice presentation, by the way, but you appear to dismiss what goes on in the police station and say, oh, not those ones. You're looking at the bigger ones. But I think this culture of restorative justice, for us to actually imbibe it, we need to train the police. It is their law that's saying the correctional facilities and the Police Act are big on restorative justice. So we need to train them for what goes on at the police station. Because in civil law countries, most of the time, the transition between the police and the court is just one room away. So we should have this. This is something we need to actually learn. The practice of restorative justice is not something we wish some part of it away. It operates everywhere, but it's a habit formation. It's not about the policeman telling you, this is domestic problem, go home and settle. Or where corruption now becomes embedded, and the highest bidder is the one who buys their way out of it. Thank you. Sorry about that.
Thank you, Ma. And each contribution or question should be up in 2 minutes. Thank you.
All right. Permit me to stand on the established protocol. Rukayat Sadudindi is my name. I'm so glad to be part of this conversation this evening. It is really an eye-opener for me. I wrote in my LLB days about concept of justice, Sharia, and then common law perspective. So any topic around justice is usually of interest to me. Presently, I'm equally doing my research on ADR with a national university on my LLM. So what really piqued me this evening is that the concept of restorative justice has always been part and parcel of Sharia legal system, to the extent that even in murder, in crime of that magnitude, the law gives room for the offender to compensate the victim. And I have been looking forward to, a way of entrenching this kind of progressive justice system in Nigeria. So, but I'm glad that the institute, the college here, is taking the lead. My question is, in a situation whereby a particular suspect, I don't know, because of the correction that the Honorable Lord put forward, that we cannot really say they are offender per se, in a situation whereby someone is consistently in breach of the law, is the discussion is there going to be a limitation to the extent to a number of times that somebody can either go for plea bargaining or any of these restorative system? That is my question. Thank you.
Thank you. Let's try and not make it too lengthy so that they get the gist of the question and are able to respond appropriately. Thank you.
Good evening, all. My name is Miriam Comboy, the director of the Restorative Justice Center in Abuja, of the FCT High Court. Now, there is an amendment that is ongoing with the AGJA, of which we are part of it. And most of the time we have talked about restorative justice here, which is a very commendable thing. But this amendment is trying to make plea bargain. There is no cut of anything, that every offense can be plea bargained. Some of us raised an objection to that, because we felt some heinous offenses like rape of a child should not be plea bargained. And I feel, and there are some things too that we ought to know about, this in the gender-based violence things. those things should not be plea bargained. Even though I'm the head of the Restorative Justice Center, but I feel that when we are doing amendments and when we are talking about plea bargain, there should be a cutoff. And we should also make our this thing known to those people who are, because the amendment is before the Senate right now. And nothing has been done over it. So I feel that this college can also lend a voice to that plea bargain should not be for every offense. We should have a yardstick. Plea bargain should be for some offenses, not every offense. Because Section 270 of ACJA gave a guideline that you need the consent of the victim for you to plea bargain. And even the guideline brought by the Attorney General's office, Section 10 of it, also did not give a blanket this thing for the prosecutor to do plea bargain and everything. But right now, we are trying to implement something that is outside there. I feel this is wrong, and I hope we'll find a way to go about it. Thank you.
Thank you very much.
Thank you very much, Madam. Let me congratulate the president of the college, Chief P.I.N. Ikwe, to SN, and also to re-echo what my Lord said, that I'm also sitting on existing protocol. My just comment and just to commend the college. Now, as a matter of substantive law, we understand that there are some criminal matters, or generally criminal matters are supposed to be exposed to ADR. But we also understand that progressively, law must reflect development of the of every society, and in various societies, restorative justice has been thrown up as a way of addressing concerns in the criminal delivery justice system of every state. And what the college is doing, in my view, is very, very timely. It's timely because it is accommodated both in the EFCC law and also in the AJA. And also, to answer the last speaker, Madam Kumbo, I think it might be too early in my view to begin to make categorizations, as to what is what could be subjected to plea bargain or not. What I just want to say is that this is a conversation that the college has started, and it's a conversation that college should drive progressively, because it's going to have a very big impact in our criminal justice delivery system. Thank you very much.
Questions and comments all coming in at once. So we'll take the last two and then get reactions.
Just one sentence to a comment that was made. God said, if your sin is as red as the scarlet, you can be forgiven. So there is no sin that cannot be forgiven. Whether it is gender-based, whether it is rape, whatever it is. If God in his infinite mercy can forgive us, who are we to say we are not going to bargain, you must go for it? Please change your mind. Thank you.
I don't want to be caught in the dilemma of determining if that's a ruling or a comment, whichever it is. I don't want to be caught up in that dilemma.
My name is A.T. Udeshukwu, a private legal practitioner. We have talked about the three aspects of restorative justice, dealing with, well, I don't want to say the offender now, because they say at what point, or to talk about the victim, but we are not talking about the society. My worry is, how do you determine the thought pattern of a multicultural society like Nigeria? The way we perceive things in the south part of this country is different from the way things are perceived in the northern part of this country. It is therefore important that when you're talking about restorative justice in Nigeria, you must find a way to make all of us think as a country. You see the problem they are having in Borno, where they are now saying they want to go ahead and then do their own restorative justice and allow those people. We in the South, we don't believe it. We are saying, look, if somebody, eye for an eye. And in so many things we deal with and address in this country, whether it's even simple admission process, committing of examination fraud or examination malpractices, in some parts of the country, they don't see it as examination malpractice. In some countries, so it's a cultural thing. There is a lot of things we need to do. And so when we are talking about restorative justice in Nigeria, you must build one society. Let us approximate what we consider to be what is the interest of the society. You remember that the last regime had a problem. When they came, the Buhari administration wanted to grant amnesty to Boko Haram, which is restorative justice. But it made a brick wall. The brick wall was, from us in the south, we said, no, you can't come and kill us, throw us, and then you say we forgive. Let us even see those people who are the offenders. Nobody came out. So, and whereas under Jonathan, they allowed restorative justice for the purposes of Niger Delta. But the answer is that we knew those people, they came. I am annoyed because my environment is degraded. They came out. You can see Tompolo. You can say, okay, where are those people who you want to restore justice to in the north? Nobody came out. They were sending out representatives. So there was a problem. So let us, in resolving this issue of restorative justice in Nigeria, determine our national consciousness. What is the value that we stand for as a country? Thank you.
Thank you, sir. And then the last, the last question or comment.
My name is Antonio. Good evening, all. I wanted to say that restorative justice has always been embedded in our traditional system. If you read Things Fall Apart, you remember the case of Okonkwo, who killed somebody. And he was asked to go on exile for 7 years. When he returned, nobody looked at him as a convict. The society accepted him, and it was as if he never left. He became integrated because he had served a term. Now, I think that all these concepts of restorative system or restorative justice is as a result of the inadequacies of our justice system. And rather than we look primarily speedy administration of justice, primarily, that's where all these things are coming from, primarily. Because sometimes you even lose sight of the justice of the case by the time the case stays for so long. And if it is in civil proceeding, you discover that there is nothing you get that ever compensates for the time that you have wasted. If you get monetary award, if you want to execute it, someone must find a way to oppose it. So it's all a waste of time. I went to New York and I sat with my classmates who were practicing in New York. In your car while you are in traffic, court proceedings are going on. Your children will be around you. You say, please keep quiet. The judge has called me. And in 15 minutes after the proceedings, you get a judgment. So I think that this idea of restorative justice as a branch of law, it will make administration of justice so expensive. It is true that it will create new work, but look at where we are. What have we done with the one that we have? So I think that while we are considering all these concepts, it is more important that we look at speedy administration of justice. And there is nothing in restorative justice that cannot be applied by a judge. For instance, my Lord spoke about a person who was convicted and she met at Kuje prisons. There was nothing wrong in convicting that person for and grant a lesser sentence. If you send somebody to go and clean National Stadium, it's a sentence. So we must look at that too. Thank you very much.
Thank you, sir. Well, I'm sure that all of those reactions I heard from the audience from the last comment will be ably handled by our speakers. So, starting from, of course, the question by Milord.
Very much. Milord, thank you for the startup of the issues. And my response to that is also a reminder of what Milord also enjoined us to do, that a change of mindset. And I particularly held that, very tight in my left palm. And that, I think, is what is answering that question, that obviously this is an alternative method. And Milord and others, perhaps, we're still looking at it from that point of traditional justice method, that we start even critiquing who is an offender at what point. I mean, with due respect. The starting point of restorative justice is that expression of guilt, which is the starting point. And that, again, obviously knocks off issue of, am I an offender, because he's already expressed willingness. And that is what we also said along at various points, including Ambassador, is that readiness to accept guilt and go through that process is a key component of the RJ. And so it is different from that, our rigid concept of adversarial and the rest of it. And again, it is, it requires, it could come at any point to answer that question specifically. It could, the referrals, it's called the referrals are always coming from somewhere. So it could come from at the police station after being charged. And then perhaps it's due to the statement that has been given, admitting partly or somehow indicating that, or through the legal reps indicating admissions partly or wholly, and that will obviously, we said, oh, we can't do this, but we must charge you, but we'll take course to ensure that this is resolved speedily as possible, suggest to the prosecution, and they might refer it to the center. And also it could come from whether the magistrate, Milord, at any point during the trial, pre-trial, and so on and so forth. I think that's the concept that we are actually looking at in terms of at what stage, rather than, I think the question is, at what stage do you trigger restorative justice, more than the case of at what stage do you become an offender? Because that question is answered straight away. Once you accept, you indicate. No one is, unlike a plea bargain, which perhaps the prosecution is allowed to kickstart depending on the circumstances. But this should come ordinarily from the defense or the offender itself, indicating that the admission of guilt. Let me not take much time further on that, Milord. I hope I'll be able to, and I'm sure the Ambassador will perhaps be able to chip in a point or two on that. In relation to the other question, and I thank you, my learned friend, for raising that issue about the police station, how it kickstarted. I'm sure that may have been the miscomprehension of what I had said about the police station. Admittedly, I did say that the restorative justice could kickstart from the police station, and it's already ongoing. But what I said is that it lacks structure, and it lacks the necessary institutionalization that should come with it. So that's what I said. I said that in reference to the procedure and the processes that is being taken, that is not in compliance with what is expected of a typical institutionalized restorative justice practice. And that is what it's meant by they are probably just practicing settlement, as it were, because there are no records. People come in and they said they are settled, they pay money, and then that file will never be processed through the system, or you may not have it. So maybe some of them will be recorded in the crime file or case for one case file or the other, but usually these matters are settled without any structure, without any reporting, no accountability. That is not what is expected of an RJ process. Any matter that is coming up from RJ process must come with that institutionalized template forms and reporting levels. So whether the police station, if they are adopting restorative, it must be clear that it's restorative justice that is being adopted. They must comply with the relevant forms, filling, and whatever agreement comes in, it goes back to the magistrate or the court that is actually will be endorsing it as a consent judgment or the judgment of that. And I think that's what it is in relation to when we said it's not standardized or it's not institutionalized, and that is, could not be counted as a restorative justice, but some other forms of an ADR. Yes, in Islamic jurisprudence, I noted that is a very germane point. What you call it? Very high-level serious cases, including murder, is allowed, permitted in Islamic jurisprudence to be settled. And again, there is no reason why it cannot also be settled under RJ. It all depends. And again, it's all about what my learned brother has also said. Issue of local content will always apply, and there can be a universal RJ template. That also I agreed. I think the other point is on the plea bargain, which I'm sure my learned brother will address, and that in terms of number of opportunities that you can benefit from RJ, that or a plea bargain on the other side. In terms of the RJ, I think there are principles and guidelines that the facilitators and the center will be guided by. There are criteria of how, even though when you are indicating that you want to be subjected to RJ, you'll probably not be qualified if you have been in breach of an RJ agreement in the past, if the circumstances also of the offense was also indicative that you are repeated offenders. I think those are also circumstances where you may not have recourse to restorative justice route or methods of justice system. I think I'll leave it at that for my other colleagues. Thank you very much.
Thank you, sir.
Now, I just want to respond to the issue you raised. You raised a vital concern about the ongoing amendment of the ACJA and the wholesale adoption of the plea bargain concept to embrace all manners of offenses. Now, that's a very serious concern because I share in your sentiment. If we extend the plea bargain concept to all kinds of offenses, I think that will create a very serious incentive for criminals, knowing that, oh, if I go and rape a child, after all, I can take the route of plea bargain. But the good thing about this is that even under Section 270 of the Administration of Criminal Justice Act, as it is, it's discretionary. Because the section says, if you look at 271, sub 1, it says it's either the defendant may propose it or the prosecution may. It's not a must. So for me, if as a prosecutor, somebody has committed a heinous offense, you know, there's a distinction between non-violent offenses and violent offenses. The offenses that are violent in nature, if you ask me to plea bargain, you apply to me to plea bargain, I will flatly say no. I will rather go for a full trial so that the society will get deserved justice from you than to accept a plea bargain, which I know it will encourage other criminals. That's my response to that. Then my Lord raised the question of the categorization of offender, victim and offender. I think my Lord said, because of the presumption of innocence, why should... Okay, at what point? Yes. Okay. Okay, it has been answered. And I just wanted to add that maybe that's a loose way of the description, offender. Of course, it is only the court that can pronounce somebody guilty. Thank you.
Thank you, my Lord, for asking that question. We appreciate you. Thank you. Usually it's at pre-trial, at trial, during imprisonment, and post-imprisonment. For the rape case, it's not always as really rape. Oh. A woman called me from my Tama, big woman. She said that the Megad imprisoned the housemaid. She had already called the police. I said, please. I did there. I said, no. I said, please call them. I'm in Abuja. I'll come over. In the next 1.5 hours, I'll be with you. Ask them to attend to other things. So I got there, called the young lady, greeted her well. How are you doing? And then, if you don't mind, let us meet, two of us. Let's meet with her. Let me ask a few questions. So she arranged. My dear, where did it take place? Was it in the house, in the kiosk of Megad? Saying the kiosk. Okay. How many times? She kept quiet. I said, Madam, you know the answer. When it was happening, did you cry? She said she wanted to shout. You wanted to? I said, yes. Okay. Madam, you know what happened? Empower them. I stood up and left. Now they have 3 children. You can imagine what would have happened if the police had come to arrest him. Because of the fear of owning up, that young man would have been in jail. So there are times you need to ask some basic questions. For an adult lady, not a kid, to be raped, we need to find out some questions. I appreciate this privilege. Thank you.
Thank you very much, sir. So, you know, the interesting thing about this kind of conversations is that there is never really a conclusion. There is no point where you get to and you say, we have exhausted all of the conversation lines. It's not possible. So this is a good place to rest it today, so that at the 3rd edition, the college will continue in enlightening and creating platforms for, you know, robust conversations such as this. Thank you very much, our august panel. My only duty is to just moderate things. It is someone that was at the helm of planning, coordinating, and putting this together. And I think it is rightfully his role to express whatever thanks or say whatever other comments are outstanding. Please warmly welcome with me to the microphone the chair of the planning committee of this program, Dr. Oke Akobundu.
May I thank the panel, my lords, my president for the opportunity, and for the guests here. What we've done today is not to provide answers, actually. We've just provoked the questions. And I guess that all our invited guests should know that whatever thoughts you have after now, just send it in to us. We'll get to the solution. But the journey has started. So on behalf of the college, I want to thank us all for coming. Thank Dr. Chikwendo and co, who came in quite early. Most of you must have that. Because of the strike of today, things were a little distorted. But they came on time and had to wait for us to start. It looked as though we wouldn't continue, but I thank God it's turned out to be successful. We have started off this as outing, and we assure you that before the next outing, you'll be hearing from us often. Thank you very much. I hear that dinner is ready, and from here, we'll just go straight to dinner. Thank you so much, panel. Thank you so much. God bless.
Okay, so I think to conclude things, please rise with me for the closing prayer, being the 2nd stanza of the national anthem. Immediately after that, we'll just take more photographs and then we'll proceed to dinner. Thank you. 2nd stanza, national anthem. O God of creation, direct our noble course, guide our leaders right, help our youth the truth to know, in love and honesty to grow, and live in just and true. Great lofty heights attain, to build a nation where peace and justice shall reign. Amen. Thank you very much. So from Chomonye Nuchea Uko, thank you. Just photographs and then we proceed to dinner. Members of the college, please, photographs. Members of the college, come forward. Photograph. Members of the college.